Yes.
My Lords, I was coming on to the point, my lady, I was coming on to the point that my friend accepts that the 1969 Act, with its reference in section 2.2 to effective control, was concerned with commercial control as well as corporate control, and I therefore submit that the question for the board is whether the legislature in 1981 intended to limit control by confining it to corporate control. And I submit if that's the question, it's very difficult to see the force of my friend's submission with great respect, because the terms of the first schedule to the 1969 Act and the terms of the third schedule to the 1981 Act are materially the same. They're the relevant provisions. And the policy considerations that apply to the two acts, 1969 and 1981, are precisely the same. See sections 8 to 9 of the 1969 Act and section 114B of the 1981 Act. So it is, I submit, inherently unlikely that the concept of control in the schedule was narrowed in 1981. Moreover, my friend has not identified any policy rationale as to why the legislature should have thought it appropriate to confine the scope of the concept of control in 1981. The board has been shown no explanatory notes, no legislative material of any other sort to suggest an intention to make what would have been a fundamental policy change between 1969 and 1981. My Lord Reid asked to see, and I understand why, the recital to the 1981 Act. I hope the board now has that in front of your lordships and your ladyships. It's a very short preamble, whereas it is expedient to make better provision for the incorporation, management, administration and winding up of companies and the consolidation of the law relating to them. Plainly, there were amendments made in 1981, but a lot of it was a consolidation.
Yeah, that was what I had been wondering.
Yes, well, that's the answer to your lordship's query. Now, it is true that one does still find in the 1981 Act references to effective control. And in my submission, the reason one finds them is because the legislature has simply, in the course of consolidation, read over what was in the earlier legislation. And I say that the correct answer to the question, what does one make of the retention of references to, quote, effective control, unquote, is that the draftsman may well have thought that the difference between the two is, to quote Justice of Appeal Clark, almost imperceptible. His lordship said that in the Court of Appeal judgment, where he did address this point. My friend said he couldn't excite great interest in the Court of Appeal with his historical analysis, and that's my recollection too. But nevertheless, the Court of Appeal's Justice of Appeal Clark did take note of my friend's submissions, because he addresses it at page 246, paragraph 30, after referring to some of the historical material. And in paragraph 30, I can't accept the submission for two reasons. First, the difference between control and effective control is almost imperceptible. The draftsman could well have thought that control was sufficient in itself. Whatever might have been the position before Cablevision, it is in the light of that decision clear that a narrow view is not to be taken of paragraph 1 of the third schedule. And then his lordship refers to provisions of the earlier legislation. And I respectfully adopt Justice of Appeals Clark's statement that the draftsman may well have thought that the distinction is almost imperceptible. One does find the phrase effective control used in the 1981 Act in at least two places. There's the reference to which my Lady Arden referred, section 139, which the board also has now, revocation of a permit. The minister may at any time revoke the permit of an overseas company. This is another part of the legislation, not what we are here concerned with, part 11, and it's 139F if there's a substantial change in the effective control of the company. And it's also to be found, as my friend indicated this morning, in section 1153 of the 1981 Act, which is page 726, specifically in relation to hotel companies. Page 726, hotel companies, 1153, where a hotel company is a subsidiary of a corporation incorporated outside Bermuda, the minister may, without prejudice to his powers under section 114B, revoke a licence in the event of the transfer of effective control of the corporation to persons who are not Bermudians. I mean, that's of interest, not least because it shows that concepts of control are to be read alongside section 114B. They're not regarded as distinct.
One way of addressing this question might be to ask what species of control would exist which could be said not to be effective. If anything, I suppose one might say effective control connotes something less, because if you've got control of something, or control of an event, at first blush that doesn't look as if there's any inhibition on the exercise of a control. On the other hand, if you have to share control with someone else, but because of your greater shareholding, for instance, you've got effective control, that might be a lesser animal, so to speak.
I would prefer to put it on the basis that effective control shows that the legislature has a concern with substance and with reality, and it's not just concerned with company law questions, right, which can be, I'm not suggesting of course they always are, but can be technical questions as to ownership. One's concerned with substance and reality, but then the question is whether the concept of control in Schedule 1 is intended to exclude questions of effective control, notwithstanding the structure of the 1969 Act and the fact that the substance of the provisions of the 69 Act, Schedule 1, Sections 8 to 9, are all read across to the 1981 Act. So we respectfully submit that historical analysis, again, together with the contents of Schedule 3, together with the purposive approach, they all support the approach taken by the Court of Appeal. Then I need to address the point, well, if the Act is concerned with commercial control, does this offend legal certainty? Does it offend the principle of no doubtful penalisation? And in my submission, this principle of giving a strict construction to provisions because they involve penalisation does not apply if the provisions are regulatory in nature, if they arise in a context which promotes an important public policy. And there is authority for that proposition. The Court of Appeal in London, page 552 of the bundle of authorities, the board will see at page 552 the Court of Appeal judgment in Secretary of State for Trade and Industry against Deverell, 2001 Chancery. And this is a case under the Company Directors Disqualification Act. The judgment of the Court of Appeal was given by Lord Justice Morritt. And if the board, please, would go to paragraph 26 on page 563 of the bundle, paragraph 26, His Lordship, Lord Justice Morritt, refers to an earlier decision by the Vice-Chancellor, Sir Nicholas Brown-Wilkinson, in re low-line electric motors. And as Lord Justice Morritt says at paragraph 26, there the Vice-Chancellor was concerned with an allegation that the person in question was a de facto director, not a shadow director. He said of the latter that the definition presupposes there is a board of directors who acted in accordance with instructions from someone else, the eminence grise or shadow director. He rejected the submission that because the section had penal consequences, the word director should be strictly construed. As the paramount purpose of disqualification is the protection of the public, he approached the question of construction on the normal basis. And there's a bit extra over the page, page 566, at paragraph 35, Lord Justice Morritt says, His Lordship proposed to express his conclusions on these and other issues in a number of propositions. The first, the definition of a shadow director is to be construed in the normal way to give effect to the parliamentary attention ascertainable from the mischief to be dealt with and the words used. In particular, as the purpose of the Act is the protection of the public and as the definition is used in other legislative contexts, it should not be strictly construed because it also has quasi-penal consequences in the context of the Disqualification Act. And His Lordship agreed with the statement of the Vice-Chancellor. And to like effect is a more recent judgment of Mr. Justice Warren, which can be found at page 576 of the bundle, Re Digital Satellite Warranty Cover Limited, in the context of financial services, and the relevant passage in that judgment can be found on page 590, paragraph 60, letter F on page 590. He, as counsel, submits that the relevant provisions should be construed restrictively so as to bring within the scope of regulation only types of contract which clearly fall within those provisions. This is because breach of the general prohibition is a criminal offence and penal provisions are not to be found in the absence of clear language. And there's a reference to Benyon and the principle against doubtful penalisation. 61, this principle is no doubt an important principle of public policy, but a penal enactment will not, as Benyon explains, be given a strict construction if other interpretative factors weigh more heavily in the scales. And then there's a reference to the Vice-Chancellor, Sir Nicholas Brown-Wilkinson's judgment, which the board has already seen mentioned by Justice Morritt. And over the page is a reference to Lord Justice Morritt's judgment. And at 62, in the present case, one of the central purposes of the financial services legislation is to regulate insurance businesses for the protection of the public and to implement the requirements of the first directive, etc., etc. In those circumstances, a restrictive construction is not called for simply because certain conduct incurs penal sanctions.
Well, Penny, I think the concern which you might want to address is not so much whether it should be narrowly construed, but whether the commercial rather than corporate approach to control sets you adrift on a foggy sea with no marker buoys. And in circumstances where a company could, for reasons entirely outside its own control, its own corporate control, let's put it that way, drift in and out of commercial control by somebody else according to financial and business matters which it's not really in charge of.
Yes. Well, the answer to that in my submission is if there's any doubt, it has the opportunity to seek a licence under section 114B. It's not as if this legislation denies the company a proper means of regularising its conduct. And any company that has concerns of this nature, of course, would be well advised to make such an application. That's the first answer. The second answer is that if my friend is correct in the concession he makes in his written case, and I say he is, that under the 1969 Act, effective control meant that the legislation was concerned with commercial control as well as corporate control, then the legislature took on board the dangers, the risks of uncertainty, but nevertheless decided, for what were no doubt proper regulatory interests, that commercial considerations should be taken into account. And under section 2.2 of the 1969 Act, that was a risk that any company was subject to, that it could be said at any time that effective control has passed abroad, perhaps for reasons outside your domain, but nevertheless, that was a risk under the 1969 Act. It's also the case that effective control is recognised by the legislature in section 1153 of the 1981 Act, and it's recognised in section 139 of the 1981 Act. So I don't, for my part, accept that risks of uncertainty provide an answer to what we say is a construction that is required by the language of the 1981 Act and is necessary to ensure that the 1981 Act fulfills the public policy purposes that apply. What I do accept, of course, is that there may be cases where a fine line has to be drawn. That's what Justice of Appeal Clark acknowledged. He acknowledged it was paragraph 47 of his lordship's judgment there. Of course there will be cases, but that is inherently the case whenever the law, whenever legislation uses a concept that is not a concept that is can be applied without reference to the circumstances of the particular case, by reference to public policy considerations. So that's my answer to that concern. I recognise, of course, there will be hard cases, but there often are in the law whenever legislation uses a concept based on qualitative concepts. And it doesn't remove the need, in my submission, doesn't remove the need for the board to ask itself whether in this statutory context, having regard to language and purpose and history, the legislature of Bermuda was imposing more than a corporate test in the circumstances of this case. That's the question for the board to answer. Of course, also, I say that in the vast majority of cases, the answer will be clear. I mean, there will be hard cases. There may be hard cases. But I don't accept that the concept is a difficult one to apply in the vast majority of cases here. And that was so under the 1969 Act. I also submit, those are my submissions on language, on purpose, and on statutory context, including the historical context. But
could I
of course,
ask you, there were two other aspects of the statutory context that we had noted, which you might want to comment on.
Yes.
One was the power of the minister to make inquiries under Section 119
Yes.
was directed towards corporate control. And the other was the locus poenitentiae, as it were, provided by paragraph 2.2 of the schedule, was concerned with situations where corporate control had passed to some external, some non-Bermudian body.
But dealing with them in the reverse order, 2.2 is simply an application of the specific corporate control provisions in 2.1 and in 1.2. And I have no quarrel, of course, with those provisions. I say that they don't affect either our submission on language, which is that 1.1 is the general provision, and what follows, including 2.2, is specific, that doesn't cut down on the general, and 2.2 doesn't also affect the purposive arguments and the...
So is it really a sort of so what point?
Yes.
That although there is special provision made for corporate control passing, and there's none for commercial control passing, so what?
Because it's in the context dealing specifically with corporate control. It's not entirely surprising that in that context that's what is addressed. The other point, 1192, this is a provision that we rely upon. We don't accept it, assists my friend. The minister has a power to require information, and the minister may specify, this is page 729, the minister may specify in the notice the facts in relation to the officers, shareholdings, and other matters relating to the control of the company. Again, if that provides any assistance, we say it supports our case because it's not specific, it's not limited, and it confers a broad power on the minister to require information about anything that may assist, whether or not it's in relation to officers or shareholders. That's how I put it. Now, but that's not the end of this question of construction, because the board does not come to this afresh. These issues have already been addressed by the board in Bermuda Cablevision. Now, I entirely accept, as my friend has persuasively submitted, that the main thrust of the concern of the board in Bermuda Cablevision was with corporate control. Of course I accept that, although it is true, nevertheless, that there is a sentence where Lord Steyn comes to apply the principles to the facts of the case. It's page 546 of the bundle at letter H, where he refers to the consulting agreement. And the consulting agreement is not a question of corporate control. But I accept the thrust of my friend's point. This was an easy case in terms of its facts in relation to corporate control. What I do, however, submit is that the approach adopted by Lord Steyn for the board is inconsistent as a matter of principle with the submissions that my friend has made, that control in Schedule 3 is confined to corporate matters. And I submit that because if the board goes back to 545, this is page 207 of the report, but 545 of the bundle, after referring at 545G to H to the need to interpret control by reference to its context, Lord Steyn says just above H, contrary to the submissions of counsel for the appellants, the expression controlled by Bermudians is not a term of art. In other words, he's not giving it a specific, narrow interpretation that there are only certain factors that can be taken into account. He then says that paragraph 1.1 is the general provision, and what follows is without prejudice. Nothing in part 1 of Schedule 3 warrants a restrictive interpretation of paragraph 1.1 to limit its scope to control by means of a vote at general meetings. And then he carries on with that. And in the next sentence, that the legislature was alive to the fact that businessmen might, by arrangement, artifice, or device, create the appearance of compliance with the legislation is made clear elsewhere. And then lower down, at just under letter E, having referred to Daimler, their lordships are satisfied there's nothing in the contextual scene which justifies any restriction on the natural width of the expression controlled by Bermudians. Indeed, if one has regard to the purpose of the legislation, this conclusion is reinforced. The purpose of the requirement is plainly to ensure that Bermudian resources remain Bermudian, and it must have been intended to make an effective provision to this end, giving the words their ordinary meaning achieves this legislative purpose. Now, I don't accept, with great respect to my friend, that those statements are consistent with limiting the concept of control to corporate control. Those I accept were the circumstances of the case, but as a matter of interpretation, Lord Steyne, in my submission, was plainly taking a broader approach, and doing so in part by reference to what his lordship regarded as the statutory purpose being, one, to prevent arrangements, artifices, or device, and two, to ensure that Bermudian resources remain Bermudian, subject, of course, to the power of the minister to give a licence. So I say that the board is in the position that this ground has been trodden over before. The board is not bound by what Lord Steyne said for the board in that case, with the agreement of Lord Berwick, Lord Brown-Wilkinson, Lord Cook of Thornton, and Lord Clyde, but it is elementary that the board will not depart from an earlier decision of the board unless it is satisfied that the principles laid down were wrong. The board has the statement of some of the authorities, the relevant authorities, in the recent book by Lord Mance and Mr. Turner, with which the board is very familiar. Can I very briefly just remind the board of the relevant statements? Lord Mance and Mr. Turner deal with this at page 136, and at paragraph 510 they refer to the old cases, Ridsdale and Gideon Nakambule, which Ridsdale was 1877, Gideon Nakambule was 1950, that its prior decisions, this is 510, its prior decisions should be given very great weight and not reopened without the greatest hesitation. I don't suggest that's the modern approach. The modern approach is on page 137 at paragraph 513, where there's a reference to Lord Slynn's advice for the board in Lewis and Attorney General, that the board should follow a previous decision unless they are satisfied that the principle laid down was wrong, not least since the opinion was given recently. Need for legal certainty demands they should be very reluctant to depart from recent fully reasoned decisions unless there are strong reasons to do so. So I don't put it higher than that there is a presumption that the board will follow earlier decisions unless the board is satisfied that the earlier decision is wrong. There's a strong onus on my friend to satisfy the board that the reasoning of Stain was incorrect. And for all those reasons, we respectfully submit that the Court of Appeal were correct in the analysis they adopted in Justice of Appeal Clark's judgment of the meaning of Schedule 3 to the 1981 Act.
Could I ask you a question?
Yes, of course.
Moving on to something else. In the normal course, control is a common word commonly used in company law terms, and it would mean controlling influence over the management or policies of the board. In this situation, in the case of the Bermuda Companies Act 1981, does it also include control over the economic resources of the company?
In my submission, in this context, it allows consideration of both policies and resources because the two of them are likely to go together. I mean, they may diverge, but they're likely to go together. It enables those who are administering the legislation to ask the question, who is in the driving seat? And that may be as to management, it may be as to policies, it may be as to resources.
That question seemed to me to be relevant to the question of which facts one selected and how one evaluated the facts.
I respectfully agree. May I turn to the circumstances of this case? Our submission is this. If we're wrong on the question of the legal test and the Act is concerned only with corporate control, then that's the end of the case. And my friend succeeds. If we are right in our submission that the concept of control allows consideration of more than corporate control, it allows consideration of commercial factors, control of resources, control of policies, who is in the driving seat, then we do respectfully submit that the board will be very slow to intervene in relation to the application of the legal test to the circumstances of this case. And there have been three levels of consideration of this case. The first was by the Bar Council, which is the regulator in this context. The second was by the Chief Justice. And the third is by the Court of Appeal. And I'll come to the Court of Appeal judgment in a moment, but plainly they were satisfied that control in this case was held offshore. It was held by Bermuda Global. But can I just make the point that although the Chief Justice at first instance, Chief Justice Caverley, was against us as to the legal test, he accepted that the appellant is commercially beholden, that was the phrase he used, to Walker's Global. Can I just show the board that reference? It's in the record and it's at page 203. This is near the end of the judgment of Chief Justice Caverley. It's paragraph 52, and no doubt the board will want to read all of this, but can I just highlight the passage that I have in mind? It's in line 8, and it's the sentence, that's the arrangement here, this is a model which merely makes the company commercially beholden to a key foreign supplier of product, brand, or intellectual property rights, logistical support, and or financial support. And his lordship didn't think that was enough. But that's what he accepted, that the appellant is commercially beholden to Walker's Global, and Justice of Appeal Clark noted that finding in his Lordship's judgment for the Court of Appeal at page 250. And at page 250, at the bottom of paragraph 40, the Court of Appeal referred to the fact that the language that the Chief Justice was using, commercially beholden, was an echo of the language used by the Bar Council when it refused a certificate to the appellant. And the board will see that in the decision letter, which is at page 85. And at page 85 is the letter of the 10th of June 2016 to Mr. Taylor. At paragraph 2, the President of the Bar Council says the company will be dependent on Walker's Global in financial and organisational terms, and there's a bit of detail. And then in the 7th line, the reality of the proposed arrangement will be that the company will be so beholden to Walker's Global that the latter is effectively in control. So my point is that the board has 3 levels of assessment: the Bar Council, the Chief Justice, and the Court of Appeal, all of which have been satisfied that in organisational, in commercial, in policy terms, control is exercised by Walker's Global. And although there is a right of appeal, I do submit that if the board rejects my friend's submissions as to the correct legal test, there is, with respect, no basis for him to invite the board to conduct a further analysis of the facts of this case and for the board to substitute its view of the facts of this case for that of those who have looked at this matter in Bermuda. I emphasise, of course, if my friend is right on the legal test, that's an entirely different matter. My Lord Kerr asked my friend what is in it for Walker's Global. And we draw attention to the fact that Walker's Global are not generally in the business of making loans. They're not generally in the business of providing administrative services to other companies. They are a highly professional law firm. And they have entered, in my submission, they have entered into this relationship with Mr. Taylor, with Walker's Bermuda, because they, Walker's Global, wish to enter, in substance, into the Bermuda legal market, which they recognise, no doubt correctly, as a valuable opportunity for Walker's Global.
Not sure if that's being seriously contested. I think it was said Walker's wants to be everywhere.
Indeed.
Yes.
Indeed. That's the reality of the matter. And we say that the reality of this case, if one is entitled to look at it by reference to commercial control, if one is entitled to ask the question, who is in the driving seat, it's not merely that the Court of Appeal's approach is within the scope of their proper measure of judgment as the local court. I would respectfully submit it's plain and obvious that commercial control in this case is held by Walker's Global. And we have drawn attention, I don't want to labour the point because the board has all these matters, but can I just respond to my friend's comments on each of them? We've drawn attention to 4 elements of the commercial relationship, the first of which concerns the branding provisions, and we've drawn attention to the fact that the rights in the name of the Bermuda company are held offshore. It's entirely a matter for Walker's Global to retain all goodwill in relation to that name in that business once the relationship ends. The appellant is entirely dependent on Walker's Global for its branding. That is for the very identity of this company. And the goodwill in the company, in the business, belongs to Walker's Global. Of course, it is correct that at the end of the relationship, there will be goodwill enjoyed by Mr. Taylor and others who have worked with him. But the goodwill in Walker's Bermuda reverts to Walker's Global. And indeed, as my Lord Briggs suggested this morning, Walker's Global, perfectly entitled to set up another franchising agreement using that same name in Bermuda. They enjoy the rights. And if you're asking the question, or if you're posing the question by reference to Lord Staines's principle, the purpose of the requirement is plainly to ensure that Bermudian resources remain Bermudian, the goodwill of the business is enjoyed offshore. It's a Bermudian resource, but it's owned by non-Bermudians. Walker's Global are seeking to expand into the Bermuda market using a local firm as the means of expanding their global footprint. So it covers Bermuda and indeed covers those Bermuda resources. And I emphasise, I'm not saying that's a bad thing. It may well be entirely appropriate, but it needs a licence. That's the first factor that we've drawn attention to. And as Justice of Appeal Clark said, it may well be that one or more of these factors considered in isolation would not be enough. It's the combination of them that we draw particular attention to. He said that at paragraph 46, Roman 8 of the judgment, record page 254. The second element is the licensing fee and the services fee. Now, my friend drew attention to the fact that the profits of the business are not enjoyed by Walker's Global. The profits are enjoyed by Walker's Bermuda. But of course, it's the profits after the payment of the license fee and the services fee. And we know, and all the detail is in the printed cases, we know that the licensing fee is $500,000 a year. We know that the appellant is also required to pay a services fee, which is determined by the application of the formula in Schedule 2, it's record page 114, and that formula is an allocation of the total costs for all the affiliated firms plus a markup of 6%. There's no evidence from the appellant as to the amount that will involve each year, and there's no business plan that indicates that there are going to be substantial profits once the licensing fee and the services fee has been paid. It's also correct, as my friend submitted, that the Walker's Bermuda are entitled to refuse the provision of any of these services, but there's no evidence to suggest that that is realistic. There's no evidence to suggest that's going to happen. See Justice of Appeal Clerk at paragraph 46, Roman 4, page 253. Again, there's no business plan dealing with these matters. Justice of Appeal Clerk concluded on this at paragraph 46.7. Could I just ask the board to turn up the record at page 254? It's paragraph 46.7. His Lordship concluded for the Court of Appeal, the top of page 254, these financial obligations, that's the services fee and the licensing fee, are likely in practice to confer very substantial power on Walkers Global over the conduct of Walkers Bermuda. Then there's the loan agreement.
Just pausing there, I mean, that will be true, won't it, of most working capital financing arrangements?
Yes, that's why one has, in my submission, one looks at this as one element of the overall picture. And I'm not suggesting, nor was Justice of Appeal Clerk, that if that were the only factor, that one would arrive at the conclusion that this amounted to commercial control. One's got to look at all of the factors together. That's the submission I made, but I accept that point, my Lord. So one has the branding provisions associated with goodwill. One has the extensive fees that have to be paid. There's also the draft loan agreement, which envisages a loan of $5 million US dollars that is going to be provided by Walkers Global to Walkers Bermuda. The terms and conditions are set out in the loan agreement, and it's true that Walkers Global, in setting the terms for repayment, this is clause 4.2 at page 124, they may not specify an amount for repayment which would cause the borrower to become unable to pay its debts as they fall due, but nevertheless it confers very substantial power and discretion on Walkers Global. It provides it with, as Justice of Appeal Clerk said, page 253, paragraph 46, Roman 5, confers a substantial discretion on Walkers Global and provides it with a powerful control lever. And the fourth matter, is a very striking matter, are the statements made by Walkers Global itself. And can I take the board, please, to what was said by Walkers Global and then address the answers that my friend has offered to this. It's the record of page 143 through to 146. And at 143, the board sees a press release that was issued by Walkers Global in May 2015, and it says, the heading is Walkers announces major expansion in response to client demand. It says, in response to consistent client demand, Walkers has announced it will be re-entering the corporate and financial fiduciary services business with the launch of Walkers Professional Services. The firm will also be expanding its global legal footprint to Bermuda, where it plans to open an office, becoming the first major international offshore firm to enter that market as a new entrant. And then halfway down the page, there's the heading Bermuda. The firm has announced it intends to open an office in Bermuda, making Walkers the first major international offshore firm to enter the Bermuda market. Then in the next paragraph, there's a reference to what the clients had said. And then this, as with our other global office, we intend to become a major force in the legal services industry in Bermuda and to grow and develop talent in that jurisdiction, said the office managing partner. And then at 144, there's another press article, Walkers expands into Bermuda professional services, and halfway down the page, there's the paragraph, now it hopes to gain permission from the relevant authorities to open an office in Bermuda, etc., etc. Mr. Rogers, Walker's managing partner, is referred to, as is Ingrid Pearce, the global managing partner. And 2 paragraphs further down, Rogers, it's fairly early days in terms of the physical location. We have secured a local Bermuda lawyer, and we hope we will be open by the end of the year. We certainly intend to recruit locally. We've had discussions with lawyers in Bermuda. It's an ongoing process to get to the opening date. We have deliberately decided to go with a greenfield process. We're not merging with anyone. And finally, over the page, there's an article from the Royal Gazette in Bermuda, and under the photograph of Miss Pearce, she...
Which page is it, please, Lord Benwick?
I'm sorry, my lord?
Which page?
This is page 145.
145, thank you.
There's a photograph of Miss Pearce, who is the managing partner in Cayman, and she is quoted under her photograph as saying...
She's the global managing partner.
Global managing partner, yes. Yeah. We've thought for quite some time, we've had clients ask us as well, whether we would be able to have a practice in and provide Bermuda legal services. We've thought about it. She said it's too early to say how many jobs there will be. And then on the next page, 146, in paragraph 3, the Singapore managing partner, I think he's the managing partner of Walkers Global, but he's in Singapore. He says, Mr. Rogers, as with our other global offices, we intend to become a major force in the legal services industry in Bermuda and to grow and develop talent in that jurisdiction, etc., etc. Now, the Court of Appeal, Justice of Appeal Clark, drew attention to the fact that Mr. Taylor has sworn 3 affidavits in these proceedings, but he has not assisted the lower courts or the board in relation to discussions that he has had with Walkers Global as to when they commenced, what they said to him about these public statements, and what he said to them in response. All he has done is to comment in his first affidavit. Can I invite the board's attention to page 11 of the record? It's page 11, and it's paragraph, at the top of page 11, it's paragraph 15E. And what Mr. Taylor says is this: as far as any statements allegedly made by representatives of Walkers Global are concerned, any such statements, if indeed they were made, were clearly intended and could only have been made for the purpose of promoting the Walkers brand and nothing more. Well, the Court of Appeal was unimpressed, and in my submission, rightly unimpressed. There is no evidence from Walkers Global to suggest that these statements were not made. There's no evidence, in fact, there's no evidence from them at all. There's certainly no evidence to suggest that these alleged statements were not made, and there's no explanation of these statements. There's no evidence suggesting that their plans changed or that Mr. Taylor persuaded them that it wasn't possible to follow that model and some other model was needed. And Justice of Appeal Clark deals with this in the record at page 255. If I could invite the board, please, to go to that, page 255, at paragraph 48, where his lordship says, it seems to his lordship unfortunate that no evidence was filed addressing what appeared in the press releases, and there's a reference to the Chief Justice being prepared to accept they were just marketing hype, which was my friend's submission. Justice of Appeal Clark, in my submission, rightly so, was more sceptical, and there's a quotation from the affidavit that I've just read out. His Lordship says, "I disagree. These were statements apparently made by professional lawyers which prima facie fall to be taken at face value as a statement of intentions. This would be so even if they were only made for promotional purposes. They may, in the nature of things, be more revealing than formal statements of position." And his Lordship was somewhat surprised that Mr. Taylor, who was poised to enter into an important professional relationship with Walkers Global, was disposed to treat the potential significance of their apparent statements in quite such dismissive terms, and at the absence of any evidence whatever from Walkers Global. I respectfully submit those comments are entirely justified, and that the press statements, in the absence of any other evidence, reveal what is in any event plain from the evidence that the board has seen, that Walkers Global is seeking itself to enter into the Bermuda market using Mr. Taylor as a conduit to do so. This is the absence of evidence, as Justice of Appeal Clark added. If we move on to paragraphs 43 to 44, which is page 251 to 252, the absence of evidence in this matter is important because, as Lordship points out at the bottom of 251, on normal principles, there's 3 lines on the bottom of 251, the appellate court needs, it seems to me, to be satisfied that the Bar Council has gone wrong in some way. Absent the error, it ought to be satisfied that a licence should have been granted. And at 45, his Lordship said that one's at least entitled to have serious doubts as to whether Walkers Bermuda would in fact be controlled by Bermudians in the light of all this material. It is true, and I accept, and my friend has made the point, these press statements were not made by Mr. Taylor. They were made some months before the appellant was incorporated. That occurred on the 16th of October 2015. But that, with great respect, misses the point. The affidavits from Mr. Taylor and the absence of affidavits from Walkers Global simply do not address the substance of what was said by Walkers Global, and the board, in my submission, is not just entitled, but is bound to proceed on the basis that that is what Walkers Global are seeking to do, and that is the reality of the arrangement. I repeat what I said to the Court of Appeal, that the Bar Council has decided this matter on the evidence available to it. The Bar Council has not made a once-and-for-all decision, nor could it do so. It is perfectly open to the appellant, if it wishes to do so, to reapply with further evidence seeking to address concerns. See paragraph 50 of the judgment of Justice Appeal Clark. But in any event, in my submission on the material before the Bar Council, before the Court of Appeal, before the board, the proper step to take is to seek a licence, as Walkers Bermuda has now done, under section 114B. So I say on the facts of this case that if the board accepts our submissions as to the legal test, then the board should be very reluctant in principle to interfere with the local assessment of how the law applies to the facts. But if the board does wish to go into the detail, then it's not merely the case that the Court of Appeal was entitled to reach the factual conclusions it did. In my submissions, they were the only proper conclusions it could reach on the material before it. Would you, Lordships and Ladies?
Yes.
That's what I wanted to submit to the board on behalf of the Bar Council. If there are other matters, further matters that I can seek to assist on, I would be happy to try to do so. But that's what I want to say.
Could I just make put one question?
Yes, of course.
You've shown us these press releases. It is possible, as I understand it, that it could be a very popular idea and that other law firms may seek to do the same thing. Would it be said that it might be more appropriate for the minister to consider the grant of licences because he can consider the number that ought to be granted, whereas the Bar Council, of course, and indeed the court, has to consider each case one at a time? It's possibly what Professor Fuller used to call a polycentric problem.
Your Ladyship is absolutely right. The Minister may, in the proper application of the policy considerations under Section 114B, take the view that the presence in Bermuda of international law firms is highly desirable up to a certain limit. And in my submission, that, in principle, I say nothing about whether that's desirable or undesirable, in principle, that would be a policy that the Minister lawfully, given the breadth of his discretion, would be entitled to adopt. Of course, if my friend is right, then those who adopt this model would have no need for a licence, and the Minister couldn't adopt such approach. And I'm told that what your Ladyship puts to me is entirely consistent with the policy statement that the Minister has made. But your Ladyship will read that and see the content of it. So yes is my answer. Thank you very much. Those are my submissions. Thank you very much.
Thank you very much, Lord Pannick. Mr. Duncan, do you follow? Mr. Todd.
My Lords, my Lady, I'll be brief in reply, if I may. Firstly, in relation to the question which my Lady Arden, has just put to the friend Lord Pannick, that is it perhaps, or might it be said, that it is more appropriate and a more appropriate matter to be dealt with by the Minister? One must bear this in mind, and it was a point I made very centrally in my opening. This case does not concern, whilst it concerns on its facts and on the particular appeal before my Lords and my Lady, a law firm which is seeking a certificate of recognition. One bears in mind that it is dependent upon the definition of control for all local companies. It's not just a matter for law firms. So if it is for the Minister to determine this question of control, on every case, it must apply to every company, whatever their line of business. So, in my respectful submission, if I may answer my lady's question, no, it is not appropriate that the matter be left to the Minister. I say that with great respect for that very reason. I'm going to work backwards, but my learned friend, Mr. Pannick, did renew the submission which he made to the Court of Appeal, that the Bar Council has not made a final decision in relation to every application which Walker's Bermuda may make. It has made a decision on the basis of the papers that were put before it, and he has drawn attention to matters which he says disclose a deficiency in the information which was given to the Bar Council, an answer to the marketing hype, the failure to put forward a business plan, the failure to provide or to explain how Walker's Bermuda were going to meet these particular fees which were payable under the agreements. My Lords and my Lady will have in mind, I know, from the chronology at page 338, where we've got a synopsis of what Mr. Taylor wrote to the Bar Council on the 2nd of February. It's to be found in the record of proceedings at page 48. Where Mr. Taylor writes, I wish to pick it up at Perhaps I can just pick it up at the bottom of the page on 48. Again, I can only reiterate that no agreements have been signed between Walkers and the company. Contrary to your suggestion, it must therefore follow that Walkers is prepared to grant its name to a law firm in another jurisdiction with no contemplation of the commercial terms. I think we can go over that. And then on to the next. He says over the page, having reached a satisfactory understanding based on those negotiations, there's no reason to enter into documents in advance as the company did not yet exist. In any event, as previously stated, the terms of these agreements will be commercially sensitive and confidential, and it is not reasonable or sensible to suggest that the company should disclose them to a panel of individuals, all of whom work for rival firms with which the company will be competing. Despite the fact that I failed to see how reviewing the proposed commercial agreements that the company will enter into with Walkers in the event the certificate is granted could possibly assist with determining direct or indirect beneficial ownership. And that was the point that was being pursued at the time. I have offered to retain independent leading counsel in London to review the terms of the arrangements with Walkers and to confirm the point about beneficial ownership. So the concern was clearly there, and it is, we can't hide from the fact that the Bar Council is made up of Walkers Bermuda's competitors. That is the fact, and whilst it is fine for my friend to say, well, they're exercising some regulatory function, of course they are, but they are going to, one has to approach this, looking at this in a sensitive yet realistic way. Was it really right? Could the legislature have really contemplated that when a person makes an application for a certificate of recognition, they have to make available to the Bar Council, which is comprised of their competitors, that commercially sensitive information relating to business plans and the like? And
could the press statements not have been disavowed without the release of confidential information?
What was said in relation to those? What was said in relation to those press statements, my lord, was this: the line that was being pursued, and we see this very clearly from the way the chronology is developed at 334 onwards. That what, as a result of these press statements, what the Bar Council fastened on is at page 334 of the records.
Yes.
The press reports were on the 21st of May, Walkers Global made its announcements about opening an office. And they were 21st and 28th of May. And then the next, then on the 16th of October 2015, Walkers Bermuda was incorporated. And on the 20th of October, it applied for a certificate of recognition. So they said that that letter was sent off. And then on the 12th of November, you see, my lord, see at page 335, Bermuda Bar Council acknowledged receipt of Walker Bermuda's application, referred to the services to be provided, stating the Bar Council would like to have a clear understanding of what functions and tasks the overseas company will perform for the Bermuda company. And then, so then Bennett Jones wrote to the Bar Council referring to that letter and informed Bar Council of the nature of the services it was envisioned that Walkers Global would provide or procure to support the growth of the Bermuda business. And then the Bar Council wrote on the 25th of November, the Bar Council needs to understand whether the beneficial ownership of the company resides with Mr. Barrett and or Miss Barrett and or Mr. Taylor, referring to the statement made in Mr. Bennett Jones' letter of the 22nd of October that the company has reached commercial agreements with Walkers Global, stating the Bar Council would like to understand the commercial arrangement to ascertain whether in fact beneficial ownership of the company actually lies with Walkers and its principals, requesting copies of the agreement, and so on. So, and that inquiry as to beneficial ownership went right through. That went right through into the next year, and they just focused on this benefits of ownership, beneficial ownership, right through until, so I can't read that, until the final letter of the 10th of June, when 10th of June 2016, when they first raised the question of control of a local company. So after when the hype was that the business development or advertising statements, or what I call the marketing hype, were made in early 2015, May 2015. And that was pursued as a matter going to legal and beneficial ownership of the companies. And that was pursued by the Bar Council on that basis. And those questions were answered. And it was only sometime later, on the last letter of the 10th of June, when there was an actual refusal, it became the question of the control of the local company. So the answers to the questions being raised were actually directed to the questions being raised. So, but my Lord, yes, of course they could have said, well, you know, we're not going to give you business plans, but no, that the marketing hype is wrong, because what we understood the Bar Council were getting from the marketing hype was the question of beneficial ownership, and that was addressed in the correspondence. So, Lord, that's the answer I make to my Lord in relation to that. My Lord, just two other points, unless there are other points you wish me to address, and that is the question of whether or not we are so beholden. It is correct, as my friend has said, that the Chief Justice and the Court of Appeal, and I think, the Bar Council also said that Walker's Bermuda would be beholden to Walker's Global. My Lords, because somebody is so beholden, I do not accept, and I don't think it follows, I submit it doesn't necessarily follow, that because a person is beholden, the person to whom that person is beholden is in a position to exercise control over the person who is so beholden. Where a person is beholden, yes, they're beholden if they continue continue with the arrangements. But here we know that the arrangements that Walker's Bermuda were not obliged to continue the arrangements. They could have sought services elsewhere. Of course, they couldn't have sought the Walker's name elsewhere, but they could have sought financing and the commercial services elsewhere. So in my respectful submission, because somebody is beholden does not mean that the person to whom they are beholden is in a position to exercise control over.
It can't be. I mean, if you're a primary producer of an agricultural product and you sell, you enter into an exclusive agreement to supply a US or a European supermarket.
Yes.
You're very beholden to the person who's going to buy your goods, who will have enormous control over the commercial terms on which those goods are bought. But that doesn't give rise to control.
No, indeed. That is exactly the point in my respectful submission. And we are here talking in terms of commercial control. So I say the focus of the legislation, as I've made the submissions before, is on corporate control. I'm not going to go over those points again. The final point I wish to make, subject to my lords and my lady, is this. Yes, Mr. Taylor has made an application to the Minister. I said that in opening, in answer to my Lord Reid's question about whether or not the Minister was aware of these proceedings. We believe he is well aware of these proceedings. In fact, the application made by Mr. Taylor was not made as a result of the ministerial statement, but in fact Mr. Taylor made his application some 18 months ago. It has not yet been processed one way or the other. Oh, sorry, it might be being processed, but the process has not been completed by refusing or granting the licence, notwithstanding some, can I put it this way, chivying from the applicant. My lords, Kevin, do you want anything else?
Don't actually have the date on which he lodged his application.
We do, my lady. He actually, I have it noted down somewhere. You got it? My lady, Walker's Bermuda made an application to the Minister of Finance under cover of a letter dated the 27th of July 2017. And that's the application which has not yet been determined the application was made without prejudice to the contention that the company is controlled by Bermudians for the purposes of the Act. And it's not clear, notwithstanding the ministerial statement, which was made in December, we're now, where are we, January, was it? Okay, it's only a month and we have had the Christmas break, but it's not clear when any such applications will be processed. And of course, at the moment, Walker's Bermuda is not practicing law because it can't do so, but it does hold commercial premises. And that is the position. I just wish to inform you of that fact.
Could I just add one point? I don't act for the Minister, but it may be that the Minister did not process the application because the Minister was considering what the policy should be, and that policy has now been announced. We don't know.
Lords, unless I can assist you further, those are my submissions in reply.
Thank you very much, Mr. Todd. Well, we're very grateful to all counsel for their contributions and to those sitting behind them. The case raises really quite an important and interesting point. Like most short points, it's difficult. We'll now take time to consider our advice, which we will tender to Her Majesty.
Thank you.